Welcome to Conscious Fever with Carl Price on 97thebeatfm.com. Welcome to Conscious Fever with Carl Price on 97thebeatfm.com.
Good evening and welcome to Conscious Fever here on 97 The Beat FM and 97thebeatfm.com. I am Carl Price. I am here tonight with DJ Ice. Good evening, DJ Ice. How are you tonight, sir?
Good evening, sir. Good evening. I'm good. How about you?
I'm doing well. I didn't get much sleep last night, so I'm going to get out of here and get some sleep, I think, before I go to court tomorrow. But anyway, I've got a special person sitting next to me and that's joined us tonight, DJ Ice. It is the Honorable Judge David Bowles of the Jefferson District Court, because he is, he is here tonight to talk about probate court. And to some of you all who are logging in from across the country, your jurisdiction may refer to it as surrogate court. But this is some good information. I think this is some important information. I think you would agree, Judge, that these people need to know, that everybody needs to know, because I'm going to set this up this way. This is the way I'm going to set this up. As a lawyer for 27 going on to 28 years now, one of the things that I've noticed is that there are a lot of families that are one big happy family until a parent passes.
The last parent dies, and all the dysfunction in the family rises.
All of it rises to the top, and it has a lot to do with the fact that a lot of individuals and a lot of families have not really prepared for the probate process. Most don't even know about the probate process. So that's what we're going to talk about tonight. We're going to try to make sure that you all understand that there is life after death. Is that a fair way to say that? At least in court.
In court, yes, there is.
At least in court. Many people think that legal affairs of a deceased individual passes with an individual, and fortunately, we know that is not necessarily the case.
Right, because people own things. They own real property, land and buildings, and they own personal property, cars, and all of the things that they bought over their lifetime. They might have life insurance policies, and those things still exist after someone dies. And so probate really is the process of identifying all those assets and all those liabilities. Sometimes they owe money too. There might be a mortgage on the house. Identifying all that stuff and passing them to the correct people in an orderly fashion.
Absolutely. So we're going to introduce our guest tonight. Our guest tonight, as I've indicated, is Judge David Bowles. Some of you all have seen the promotion, and we just felt it was necessary at this time of the year to talk about the probate process. And so we're going to pose quite a few questions to him here on 97 The Beat FM, but you can pose some questions also. Thank you all for joining us on Facebook Live. Thank you all for joining us on the YouTube channel. And of course on 97 The Beat FM, and those of you all who are joining us on 97thebeatfm.com. But if you want to call in and participate, you can. You can reach us here at 502-384-6483. That's 502-384-6483. And because I believe that there is going to be a great deal of good information that is going to be talked about tonight, I want you to share this Facebook broadcast. And so all of your friends all across the country can then come back and watch it and say, oh, Well, I thought everything ended at the time of death, and now I realize that that we don't. And I see that Lorite Way says, "Wish we had this info back when my mother passed." Well, uh, my condolences for your mother passing, Mr. Wade, but I will tell you that now we have it. I'm sorry we were not able to have this broadcast by then, but we got it now, and we're going to talk about this. So I want you all to get to know Judge David Bowles. I have worked with Judge Bowles. I worked with him when I was a prosecutor. He has an extraordinary background and had done a lot of stuff prior to becoming a judge. Was an attorney, a practicing attorney, spent a lot of time in federal court.
Yes.
Yeah. So anyway, so so let me just by way of introduction to my audience, Judge, how long have you been on the bench here in Jefferson County?
A decade now.
A decade.
I've hit the 10-year mark. And after the first of the year, I will be the oldest judge on the Jefferson District Court.
Oh, wow.
In terms of age.
Now, as a general, I mean, is the term going to give you a plaque or something for
I don't
that?
think so.
You don't think so? No. Who's the chief judge this year, by the way?
Judge Ann Haney is the chief.
Judge Ann Haney. Okay. That's a wonderful choice. I'm sure she's probably watching tonight. And Eric Carter says, "How you doing, Judge?" Maybe that's an old
Hi,
friend. But in any case, but prior to becoming a judge, what did you do? Tell the people a bit of your background.
I'm a Louisville native. I've lived here all my life. I've never lived anywhere else except for very short periods of time. For 20 years, I was a police officer. I actually retired in 2001 from the Jefferson County Police Department at the rank of lieutenant. And while I was a police officer, knew that I wanted to become a lawyer. And so I went to school at University of Louisville. At the time, they had a night school.
Mm-hmm.
So I was able to work during the day and go to law school at night. So I did that for 4 years and got my law license, I don't know, about 10 months before I was eligible to retire, and stayed that extra 10 months for a lot of good reasons.
Right.
For retirement purposes. But left the police department with a law license, and I went to work here locally with a law firm named Landrum and Schaus, which is actually a Lexington law firm, but they had a big, kind of an active Louisville office, and I worked for them until I was elected to the bench in 2008.
Okay. You got lucky with that transition, huh? Right at the time it was to retire, and it's time to go out and practice law.
Right, and it was a good transition because when I practiced law, I went into public sector defense work, which was when cities or counties or local governments got sued. I would represent them in state and federal court. We got to try a lot of cases, got to argue at in federal courts at the Sixth Circuit, at the Kentucky Supreme Court, the Court of Appeals. So it was a wonderful experience. The trial experience was the best, at least preparing me to be a judge.
Absolutely.
The trial experience was the best because I do have an understanding of what lawyers in litigation do. And so it helps me to be a better judge when I know what the lawyers are trying to do.
And I've always said that. I think the lawyers that ought to be on the bench are the ones who have practiced, who have had the litigation experience, because then they understand the litigants, particularly the attorney litigants, much better. I at least that's always been my opinion. I know there are some people out there that disagree with me. And of course, we've had people elected to the bench who hadn't had a lot of experience, and they've turned out to be extraordinary judges. But in any case, but we're here to talk about probate tonight. We're going to talk about probate, and because we want you all to know about this probate process. Does it end after death? Not according to the legal system. So we're going to take a very quick break, and then we're going to dive right into it. And I'm going to stop talking, and you're going to hear a lot from Judge David Bowles. But you're listening to Conscious Fever here on 97tobeatfm.com. I'm your host, Carl Price. And if If you want to call us and join us after the break, you can at 502-384-6483. We'll be right back.
Welcome to Conscious Fever with Carl Price on 97thebeatfm.com.
Open Eyes Enterprise presents the 2018 Masquerade New Year's Eve Party. December 31st from 10 till 2. With DJ Taz on the tables at Valley Hope Center, 10801 Deering Road.
With live entertainment from
This is comedian Meech Dog. Come check me out at the Valley Hope Center. December the 31st is going down for the Masquerade Party. Bring in your New Year's Eve with Meech Dog and friends.
For tickets, go to 2018masqueradeparty.eventbrite.com. Open Eyes Enterprise presents the 2018 Masquerade New Year's Eve Party. Show up dripping.
502 Stand Up Kentucky. Whether you're a mother or father or uncle or aunt or a person great at using contraceptives, save this date. Grab a sitter. Make Uber your designated driver because you don't want to miss the Bad Dads of Comedy Tour, brought to you by Big Mike's Comedy Blast, starring the very funny Gene Harden.
I'm bringing the Bad Dads Comedy Tour to your city. When you come right outside of TSA, you make a right, you're going to see the dog right there. Let him sniff your ass for a little bit.
Along with the very funny Eric
Have you ever
Silva.
seen the look on a woman's face when she gets more than she expected?
Hosted by the always ignorant Dwayne Cobb. Tickets can be purchased from eventbrite.com or Jambusters Saloons and more, or She Likes Beauty and Barber Salons. And remember, clapping is optional, but laughter is a must. Get your tickets now.
Welcome back to Conscious Fever, hosted by Carl Price on 97thebeatfm.com.
All right, welcome back here to Conscious Fever. I'm your host, Carl Price, on 97 The Beat FM and 97thebeatfm.com. I'm here with DJ Ice, and of course, I'm here with our guest tonight, which is Judge David Bowles. When I was growing up, Judge Bowles, I always used to hear that there are two things that were guaranteed, and it was death and taxes.
That's correct.
And we're going to talk about the guarantee of death tonight and how the legal system plays a role. So I want you to start off. I'm going to stop talking. I want you to tell the people, just as a, just for starters, what is probate court or surrogate court? What is understood to be probate court?
Well,
in the legal system.
In the legal system, and it's a word that a lot of people talk about, but they don't really know what it means. Nobody likes to think about dying, or their parents dying, or their spouses dying. The fact of the matter is, I don't know if you know, we are all going to die.
Somebody told me that.
And when we do, as I said, we are going to have stuff. In most cases, we're going to have something. We might have real property or a house. We might have personal property, cars and money and possessions that were ours, that we owned at the time that we died. We might have retirement accounts that we haven't drawn yet, or we might have life insurance policies that haven't been paid up. And so these things have to be settled. And probate, it's actually is a Latin word. It means to prove. And probate court is designed to, first of all, to bring people into court to prove someone's will. We call it a last will and testament. And that's basically a document that someone signs that says when they die, this is who gets their stuff and who's going to be in charge of distributing that stuff. Now, we also die sometimes with debts, with obligations. We have creditors when we die. So probate court is the way for the law to identify all of those assets and all of those liabilities and distribute them and settle them in an orderly legal fashion. So there's some finality to those things, and families can move on.
Okay, interesting. So let me, there's a lot of terminology in probate court, and I know it comes from the Old English law, such as intestate, testate, executor, and administrator. many people don't understand what intestate is. And just briefly, if you can just elaborate on what it means to die intestate.
Okay, so it's really simple. So we talk about someone's last will and testament. Testament means something under oath. That's what a will is. It's always done in front of witnesses, or it's usually done in front of witnesses. There are certain exceptions to that. But testate means when someone dies testate, it means they died leaving a will. They have a will. When someone dies intestate, it means they die without a will. There's always a person, an individual, who is in charge of administering an estate. An estate means somebody's stuff and their assets and liabilities after death. In a testate estate where there's a will involved, that person's called an executor. They execute the wishes of the person who's died according to the terms of the will. In an intestate estate where there is no will, those liabilities and those assets still have to be dealt with. There's a process under Kentucky law called administration, and we appoint an administrator instead of an executor. They're doing the same thing. Both an executor and administrator serve in what we call a fiduciary role. It's a role of trust. They have to have a bond set for the amount of assets in the estate, and for those people who die without a will, the law in the Commonwealth of Kentucky decides who gets whatever's left and in what order. So
in terms of priority.
In terms of priority, right.
Okay. So essentially the difference between an executor and administrator is an executor or executrix, and the difference between those two is man and woman, right? I mean, it's just an old law. So if you're an executor, you're executing the wishes of the individual who made the will and that has passed away. And if you're the tor, you are a male generally,
right?
And the law recognizes the gender. If you're a trix, then you are a female. And the administrator is someone who is administering or carrying out, or, well, it's probably best to say administering the estate without a will.
Right.
Of a deceased person without a will. And that's administrator, or an administratrix is a female. So I saw a couple of questions here. Good to have you back, classmate from Nashville, Tennessee, or Knoxville, Tennessee. I'm not gonna put you in Nashville. I'm sorry, Ms. Freeman. But I saw a couple of questions on the screen, and one of them was, and I know it was from our friend in Baltimore. He's an attorney, Mr. Davenport, and he says he posed a question about a surviving spouse's obligation to pay the decedent, the dead spouse's debts. Is there an obligation, at least in the Commonwealth of Kentucky, for a surviving spouse to take care or pay the debts of a deceased spouse? And if there is an obligation, under what circumstances?
Well, I'm going to give you the most famous saying that judges give people, and said, that depends.
That depends. Okay.
So we're talking about spouses now. And we may get into this a little later about a spousal exemption. But generally speaking, it's the debts of the decedent that usually creditors will file claims against the estate and want to be paid before the estate is closed. Sometimes there's not enough money to pay those debts. Sometimes there's such little cash, or there's good estate planning to the point where creditors have lost out. So, and there's several kinds of debts. There's secured debt, which would be like a mortgage on a house, and that debt is must be satisfied as the house is sold or there's a transfer of ownership. Those are attached to the real property, to the real estate. Unsecured debt, most common form would be a credit card. It depends on whether the credit card was in joint names. It depends on if there's sufficient assets to pay the credit card. So oftentimes, there's a provision under Kentucky law that if someone dies and they only have $15,000 or less in assets, personal assets, and I mean money, personal property like cars, possessions, the spouse, the surviving spouse, is entitled to that first $15,000 as a matter of law. And it goes back to common law when they didn't want spouses to be destitute upon the death of someone.
Gotcha.
And in most cases, it would be a woman who, in hundreds of years ago, would be a woman who might be left destitute with the death of her husband.
Gotcha. So, and that spousal exemption applies only to personal property and not real property.
Correct.
Correct. Okay. Okay. I see a post there by Rob Madden. He says, Judge Bowles is a great judge. Jefferson County is fortunate to have him. Exclamation point 4 times.
Hi, Rob.
How you doing, Rob? So, in continuing this discussion about probate, again, if you want to call in, you may, 502-384-6483. I do apologize that we can't be in on video because it interrupts the broadcast. But you're welcome to call in and join us and pose a question at 502-384-6483. I saw another question on the post before I get back to my written questions, and that was from our friend. I always like to call names. They know I do. That's why they join this broadcast sometimes. Pete Palmer, one of the greatest mediators in Kentucky and Indiana. But anyway, Mr. Palmer asked that, or he indicated that he gets asked a lot, does the executor must the executor be a resident of the state of Kentucky?
Yeah, many years ago they required that, but now the answer to that is no. As a matter of fact, I had multiple cases on my probate docket today where the executor lived in Indiana. One lived in Florida. The Kentucky law does require that person to nominate what we call a process agent in Kentucky. So I do not have the authority as a district court judge in Kentucky to reach out and have jurisdiction over somebody who's a resident of Indiana.
Absolutely.
I have authority in Kentucky, not Indiana. But if I have a process agent for that individual in Kentucky, they must be a Kentucky resident. And it's many times it's the lawyer who agrees to be the process agent. So if I have to serve paperwork on an executor who's out of state, I will serve it on this process agent. And the agreement with the executor is that when that process agent is served, it's as if they've been served and they must respond. And that permits the court to exercise jurisdiction, to make sure things are filed on time, there's been no mismanagement of money, they're responsive to the court.
Okay.
So the answer to that is no, executors can live out of state.
Absolutely. Interesting. That's interesting. I actually didn't know that, but I haven't had that issue come up yet. But of course, Mr. Palmer obviously has. And you may have covered this, Judge, but why is probate court necessary, in your opinion?
Well,
I know we joked earlier about, the turmoil starts after the last parent passes.
Right.
But
Right. So, if in the best case scenario, someone would plan so well with their what we call an estate plan that there would be no need for probate. Somebody can die and leave a will, and there'd be no need to admit that will to probate or even have an administration of the estate if, in fact, all of the assets of the estate pass outside of probate. And here's how that happens. Accounts can be in joint survivorship, where on the death of one person, they automatically become the property of another. In most cases, that would be a spouse, but it could be a child, it could be anybody. The same thing with life insurance policies. I never encourage anyone to name their estate as the beneficiary of a life insurance policy.
But instead of named beneficiary.
Name a person. That is a contract. It passes outside the probate estate.
And so when a named person is named, or when a person is named as the beneficiary or specified in the life insurance policy, and the insurance company does contact the court, the insurance company calls that person pretty much, right?
They contact that person or that person makes a claim if they know about it. And once they're verified, they're paid the proceeds of the insurance policy.
Okay. So, and you mentioned accounts. I'm going to come back to estate planning, but you mentioned accounts. So one way to allow money in a bank account to pass outside of probate is it to have a joint account?
Yeah. If you have a joint owner, joint with survivorship, there's different ways to have accounts. And it's always the and or. So if an account is listed as Carl Price or David Bowles, that's a joint account. Okay.
Okay.
You or I have access. But if it's Carl Price and David Bowles, then we both own it and we both have rights to it. And that's not a joint, what we consider a joint bank account. When you get into life insurance policies, annuities, 401ks, those things are often specifically state jointly with the right of survivorship with an individual. Many people have 401k or some type of retirement account. And if you nominate a beneficiary on those accounts as well, those will also pass outside a probate estate. So it's only the assets that an individual owns by themselves with no beneficiary that actually pass through probate. And careful estate planning can avoid all of that.
Okay. Let me go back to something here because you mentioned this phrase earlier, estate plan.
Right.
So what help the people understand what an estate plan is?
Okay. So we talked about nobody likes to talk or think about dying, but the fact of the matter is that we all are going to die. And the first thing that I would have, many people don't have a lot of stuff, but if you have stuff, whether it's personal stuff or real property stuff like houses or land, have a will. You can consult with the lawyer. Just tell them how you want your property to be distributed when you die, and a lawyer can write a will in such a way to protect your estate as much as possible from things like taxes, from probate court. So you have a will, and you decide who gets your property, your personal property or real property when you die. An estate plan also encompasses some other things, and one would be a general power of attorney, a durable power of attorney. So I will tell you, my father died of Alzheimer's dementia. He had a durable power of attorney, and I was able to, during his illness, manage his finances, make medical decisions for him, just basically handle all of his affairs because he had a durable power of attorney that he had executed. Otherwise, my family would have had to gone through disability court. He'd have been declared disabled, and we would have had a guardian appointed. This way, I was able to do all of that through a good estate plan of my father's.
So
that's one more thing.
Okay, go ahead.
The last thing is a living will. And a living will is a document where you state your wishes if you become terminally ill, on whether you want artificial means to keep you alive. And most people do not. That doesn't mean that everybody's that way, but it makes it very easy for the family when dealing with doctors and hospitals at end of life decision time.
So let me just back up just because I want to be clear on this and I want the audience to be clear on this. Then the power of attorney. And of course, everybody, I think all the lawyers, at least here in Kentucky, know that there was an overhaul of the power of attorney statute.
Right.
And there are some new requirements. And it has to be executed like a will now, pretty much, right?
Right.
As opposed to just being executed in front of a notary. Years ago, you could just, sign in front of a notary. But now it has to be formally executed specifically as it is stated in the statute. The new ones.
The new ones, right.
Right, the new ones that are after the
there's more requirements.
Inception of the
it's
statute.
kind of in line with uniform statutes across the country that these things should be notarized. They should be executed much in the way a self-proving will would be executed with two witnesses, a notary present, and to make them valid documents recognizable by courts and the legal system.
So, and the only other thing I'm going to ask about the power of attorney is that obviously the timing of when you get the power of attorney is extremely important. I hear a lot of people talk about parents with dementia, and unfortunately, it's too late then. Right. It's too late. Yeah, you got to get it, and you got to get it when they're competent and when they're actually able to sign. Right. Absolutely. Yeah. That's interesting. I'm going to go into some other areas and then before we take a break, one of the posts there talked about, and we talked about wills just a little bit. We're going to talk about the let's see. Please explain what the public administrator does. Okay, yes, essentially, yeah. That's our friend Judge Green.
That's right.
Yeah, but so before we talk about the public administrator, I saw a post about handwritten wills. There was a lawyer, I think it was Mr. Mattingly, that said he gets asked about handwritten wills a lot.
Yeah, there's a.
First of all, I should ask, Judge. I don't mean to interrupt you, but first of all, I should ask, are they legal?
Yes, there's they can be. There's Kentucky recognizes what's called a holographic will. It must be handwritten wholly in the handwriting of we call them the testator, the person who's made it, the person who died. So it must be wholly in their handwriting and signed by them. It doesn't require witnesses. It actually doesn't have to be dated according to Kentucky law. That's something I've learned in my 10 years on the bench. These things don't even have to be dated.
Interesting.
But it's a holographic will. And I've seen more of those than I really thought I would on the bench. I still see it. I saw one this week, a holographic will that someone wrote with not an insignificant estate involved. I guess they don't want to pay lawyers.
They don't want to pay lawyers. That's right.
Pay lawyers.
That's right. So basically, in a nutshell, if I'm on my deathbed in sound mind, I can just simply take a legal pad and write out my wishes.
Absolutely.
And that's my will.
That can be your will.
But I have to sign it.
It has to be signed, and it has to have the court. I have to be able to look at it and say, oh yeah, that's a will. They knew what their stuff was, and they knew who they wanted to give it to, and they signed it. It doesn't have to have an executor nominated. I would discourage people from doing that because if they don't have those things, those type of things can fail.
Do you find that holographic wills invite confrontation from other family members sometimes, particularly when the timing is off? 2 weeks prior to the death of a loved one, all of a sudden they write a will, only in the presence of the person who's getting all the
I would say
property.
that any will made on a deathbed or 2 weeks before receives extra scrutiny, not only from the court but from the family.
But from the family. Right. Yeah. Right. Well, we've got some other questions to ask. We're going to talk about the role of the public administrator. And I'm going to talk about something that I think a lot of the personal injury lawyers that are listening on here are interested to hear about. And because I've seen this come up in my personal injury practice, is those of us who do wrongful death cases. We have insurance adjusters telling us that, I've got a lien from the child support office. And I know that there's a big legal distinction there because basically the decedent doesn't own the money. The heirs own the wrongful death proceeds. Right. So we're going to talk about that, but we're going to take, if DJ Ice is so willing, we're going to take another quick break, about a 30-second break, and we're going to come right back and we're going to dive right into this and finish up this discussion. Really good discussion, I might add, on probate. So you're listening to 97thebetfm.com and 97 The Beat FM, and you're listening to this show, Conscious Fever. I'm your host, Carl Price. We'll be right back right after this quick break.
You are listening to Conscious Fever, hosted by Carl Price on 97thebetfm.com.
You can't handle the truth.
You have a story to tell, and your story could be intimate and personal or something you want the entire world to see, because a tattoo is the most unique and personal form of individual expression. And body art is a master's craft. So when you decide to let somebody draw on your canvas, you need to seek out the truth. Truth's Tattoos have been creating world-class body art for over 10 years, and there's nothing the truth can't handle. Check out Truth's Tattoos on Facebook and Instagram, and you'll see there's other tattoo artists, and there's the truth. Stop being lied to and book your next tattoo appointment with the truth at 408-8403.
Welcome to Conscious Fever with Carl Price on 97thebetfm.com.
All right, welcome back to Conscious Fever. I'm your host, Carl Price, on 97thebetfm.com and 97thebetfm. I'm here with Jay Ice, and our guest tonight is Judge David Bowles of the Jefferson District Court, and we're talking about probate. We started off the show by saying, that phrase that two things are guaranteed, death and taxes, and we're talking about the death part tonight, right? So, but in any case, but I see, and Judge, I know you saw the question posted there from my friend in Baltimore. It says, does Kentucky law require certain family members be included as beneficiaries to a will, regardless of whether the testator, the person that has passed away, or the person that's making the will, wants the family member included?
Okay, so he's used the term family member. So under Kentucky law, you can very clearly disinherit your children.
Interesting.
If you write a will, you do not have to leave anything to your children. However, you cannot disinherit a spouse. Spouses under Kentucky law have what's called a dower interest. It's been codified in a statute. It used to be a common law interest that we got from England. When we brought all the law over from England, they had this dower and courtesy. They called it interest, but they call it a dower interest now. And a spouse is entitled to half of the personalty and 1/3 of the real property under Kentucky law. So you can write a will and disinherit your spouse, but the spouse can come into court and claim their dower interest. So to answer that question is, you don't have to leave beneficiaries in a will, but you cannot disinherit a spouse in the Commonwealth of Kentucky.
It's interesting. Now, you said half real estate or half personal property?
50, half of the personal property and 1/3 of the real property.
Yeah, 1/3 of, okay. 1/3 of the real and half of the personal.
Right.
So how does that coordinate, if that's a good word or a decent word, with the wrongful death statute? Because I know the wrongful death statute sometimes it is always plays a role in probate court behind the scenes.
It does, behind the scenes, but I will tell you that wrongful death proceeds, as a general rule of law, do not pass through the probate estate.
Right.
They are proceeds that represent future lost earnings. That's the measure of wrongful death proceeds in Kentucky, plus maybe punitive damages.
Absolutely.
Might be in there too.
Absolutely.
If the decedent had not been wrongfully killed or some accident or some negligence, and that is a whole separate statutory scheme. Those actions must be prosecuted in the circuit court, not in the district court, which has exclusive jurisdiction over probate. However, a personal representative, which is the umbrella name for an executor or an administrator, is the only person who can bring a wrongful death action in the Commonwealth of Kentucky. So
now, if that person refuses to bring the wrongful death action, it seems like I read something somewhere where the heirs then can bring the action.
Well, I mean, someone could ask that person be removed for not performing
Absolutely.
their fiduciary
Okay.
duty, and the court could remove and appoint someone else. But as a general rule, the most common case I see now are nursing home cases, where a personal representative is appointed only for the purpose of pursuing a wrongful death action in circuit court. When they list the assets of the decedent, it's usually a zero. It's usually, these people are in nursing homes. They depleted all of their assets for nursing home care. Maybe they're on Medicaid at the time, and a Medicaid bed. So probate only plays a role in appointing the appropriate person to bring that suit.
Okay. So I saw some other questions posted on the screen. The role of a public administrator in Kentucky courts. What is a public administrator, and what is his or her role?
Well, sometimes there is no suitable person to serve as either an executor or an administrator in the family or close friends. And a public administrator is actually an office. It's created by statute. It's an individual where we have a term. There's 17 district court judges, and every 4 years we appoint a public administrator, someone to handle these estates, where either there is no appropriate person to bring a probate action, or the person who was the personal representative has somehow misappropriated money, not done their duty, cannot be located. And so the public administrator's office is a very busy. I think I just read something the other day that they have 750 active cases right now.
Wow.
Half of those are cases involving minor estates, which we're not talking about tonight, where persons under 18 have either inherited money or received proceeds from some type of a personal injury litigation.
Gotcha.
And the public administrator, if there's no suitable family member, the public administrator would manage that money until they're 18 years old. So the public administrator's office is a very vital office here in our community. They handle lots and lots of cases. They resolve lots and lots of cases. And sometimes even when there's conflict within families, in many cases, I've said, hey, we have this office, this public administrator, who's a neutral third party who might be able to help your family resolve this. And sometimes everybody agrees to that and want them to have the case.
Oh, wow. Okay.
More often than not, the public administrator is appointed because there's been some kind of a problem with the person who's handling it.
Yeah. Interesting. I see a post here. Can an ex make a claim if they are not listed in the will? And I'm not sure, probably need some clarification on that, but I'm assuming that might be an ex-spouse. But if it's an ex-spouse, then
generally speaking, so if you were married and you left a will and you left everything to your spouse, and if your spouse died before you, then everything to your children. If you're divorced after that time, the law views that will as the spouse having died before you. So the entire will doesn't fail, just the part that leaves everything to the spouse. So the answer to that question was, and that means make a claim. I don't know what make a claim means.
Anybody can make a claim so long as they do it within the time frame.
We can talk about creditors in a minute, but there's no entitlement to inherit necessarily once there's a divorce.
Okay. So let's talk about creditors. Let's just jump into creditors. So John Doe dies. John Doe owes me some money.
Let's talk about if I died today.
Okay.
This will be easy because so if I died today, I owe some money to some people. I got a new Ford, and I got Ford financing on 0% financing. So I've got this car, and I owe money on it. And Ford either going to want their car or want the money when I die.
Right.
Because I signed a note. I also own a house, and I have a mortgage on that house with a local bank. And just because I die, the bank still wants their monthly.
They still want their money, right?
So, those individuals, Ford Credit and the local bank, they would, and they have people that watch these filings every day, filings and probate. They would file a claim on the estate. David Bowles owed us this amount of money. This is a claim, and so then a whole series of statutes kick in on claims. And here's generally how it works. An administrator or an executor has a certain period of time to either allow, they could pay the claim if they want, if they think it's a valid claim, or disallow the claim. And oftentimes what you hear from is usually a credit card company or a medical bill. We don't know enough about it. We're disallowing it because you won't give us any information. So we disallow the claim. In that disallowance, they have to tell the claimant that they have, if they don't file suit within 60 days over this claim. Then it becomes a contract issue, right? The claimant
Hmm.
versus the estate. So the claimant, let's say it's a doctor's office. The doctor's office within 60 days could file a suit either in district court or circuit court suing the estate for the money. And then we would have the whole litigation process where, the state would ask for proof of it, and then they would deny it, and they would, and that claim would be resolved in that way.
Gotcha.
Satisfied in that way. If it's not disallowed within the 60-day period, by operational law, it's allowed. It's allowed. And so what often happens is claims are filed in the states, and people who are acting pro se without a lawyer, and even some lawyers don't check that file for these claims. They're supposed to mail a copy to the personal representative. But if it's filed in the clerk's office, it's a good claim if it has the right language in it. And so they'll get to the end of a state, they'll settle it, and they'll send a settlement in. And we go through and we look, has it been 6 months? Are there any claims? And boom, there's claims. And there's no release of claims. There's no proof in the settlement that they paid the claim. And we have to reject those settlements because there's outstanding claims.
Outstanding claims.
So that is a frequent problem that we see is claims that have not been satisfied. And the personal representatives are usually surprised by it. So I would encourage you, if anybody has an estate open, make sure you check that file for claims on a regular basis.
Right, because sometimes the creditors just don't send the notice. They're required to send the notice, but sometimes they don't.
Right.
Yeah, sometimes they don't. Let's talk about timetables because you mentioned 6 months. So I'm going to throw these times out to you, and you tell the audience the significance of it. 60 days.
60 days. It's got there's
several for 60 days, right?
If someone dies intestate without a will, the law gives family members, those people who would be entitled to receive under the law of intestate succession, preference over appointment. So you start with the spouse, and then children, and then parents, and then siblings. After 60 days, there is no preference. So potentially a creditor could come in, if no estate's open, and ask that the public administrators be appointed after 60 days so they could get their claim filed.
Gotcha.
60 days also is the time during which a creditor, once a claim is properly disallowed, has to file suit over the claim.
Okay. And the 6 months ties into the 60 days also for the creditor's claim.
It does. So the estate must be open. If a estate is open for administration, it must stay open for a minimum of 6 months. And that is primarily for creditors to assert their claims in the estate.
Okay. And then when that claim is asserted, then the personal representative has 60 days to disallow it.
Right.
Okay. If they just, okay. Interesting. 10 years.
10 years. No estate may be administered after 10 years.
After 10 years.
Whether there's a will or no will at all. So there can be no executor or administrator appointed, nothing. Now, that doesn't, people say, well, that does leave people in a jam. If something happens after 10 years. No, they would go to circuit court for a different kind of action, a declaration of rights or something like that. They would have a remedy, because the circuit court is always a place when there's no statutory remedy. The circuit court is the court that they would file it.
Okay.
But you can admit a will to probate after 10 years. You just can't administer that estate.
You just can't administer. So you can't admit the will, but you just can't administer the estate. There's some other stuff that we want to talk about. I know I saw a post about loss of consortium, and I'm not sure what the significance of loss of consortium is.
We're getting into wrongful death.
Right. Because
that's wrongful death stuff. And I will tell you, I'm not an expert on wrongful death because I don't preside over those matters. One part of a wrongful death action I do know could be of loss of consortium claim, either
spousal loss of consortium or a minor child. Right. Okay. So some other things that I want to, we've talked about the creditors. I want to talk about, and I just want to ask you this before we get into our conclusory questions, and that is, wrongful death proceeds and probate court and child support. And I don't know, and I guess you can tell me, Judge, if this is more of a wrongful death question than it is probate court. But what is happening now in the personal injury world is that when an individual is injured in a motor vehicle collision, particularly, generally a motor vehicle collision, and that individual owes child support, the child support office is basically putting the liability carriers on notice that, this person owes money. We have a lien, pay us the money. And these liability carriers believe that they have to respond to the lien. So I just happen to have, I have a wrongful death case now. An individual was killed. He was not at fault. And when I was talking to the at fault carrier, the adjuster said, well, by the way, we've got a $34,000 child support lien. What happens to that child support lien in reference to probate court? I mean, if they can only file it in probate court, first of all, if it's my understanding, but the wrongful death proceeds do not pass through probate.
I disagree.
Okay.
I don't think it's filed in probate court. I think they would put, because the wrongful death proceeds do not pass through proceeds through probate.
Through probate, right?
And so to file a claim in probate, there would be insufficient assets in the probate estate to pay that claim.
Absolutely.
And I don't want, I get careful because the judicial canons kind of limit me on what I can say about advice. But again, those are matters that all should be addressed in the circuit court, I believe. In the circuit court.
So let me tell you what I told the adjuster. I told the adjuster, I said, well, this is just me thinking on the phone. I said, first of all, a deceased person is not entitled to wrongful death proceeds. So if these are wrongful death proceeds, they are owned by somebody else.
The statute tells you who it
right.
belongs to.
Absolutely. And if they're owned by somebody else, unless that somebody else has that debt, you can't force that deceased person's debt.
It sounds like something that you might want to litigate.
Well, I may have to litigate it if they push the lien, but they said that, this gentleman had a $34,000 child support lien, who obviously is to one of his heirs. Right, because he died, he passed without a will. And my argument was, listen, I don't, it has nothing to do with property that's owned by somebody else, because wrongful death proceeds are owned by the survivors and not by the decedent.
Well, maybe you make some.
Maybe I'll make some more law. Maybe I'll make some more law. Yeah, absolutely. Interesting. So, so that's just the, what we're dealing with out there with these child support liens and personal injury cases. And now they're, following over the wrongful death cases. So just a few more questions. One area that I really did want to touch on before we go off the air is, what is a petition to dispense? I have found that more pro se individuals, more individuals without lawyers, are going to probate court because they know about this petition to dispense.
Right. The statute, Kentucky law permits, if there's, it's a limited right. Okay. If someone dies and they only had personal assets, that means non-real estate assets of $15,000 or less, there are certain people who are entitled to that off the top. The first is a surviving spouse, and there's virtually no questions about it. A surviving spouse is entitled to the first $15,000, and if there's only $13,000, the estate can be dispensed with. You follow me?
I'm following. Right.
Administer the estate. Now, so let's say there's no surviving spouse, but there's surviving children. Here's the catch in that, and it's kind of a complicated catch. The statute is written in such a way the surviving children can take that exemption as well and dispense with administration. If there was a will and a child was disinherited or left a limited amount in the will, they can only take to the extent they would have taken under the will. So if there's 3 children and in the will, one child was disinherited, left out of the will, only the other 2 can take the spousal exemption. What I call this, can take the exemption. We call it the spousal exemption. Can take the exemption, and dispense with administration.
Interesting. So this petition to dispense, I see a lot of creditors doing it also. So when I've seen creditors file a petition to dispense that they're a preferred creditor.
If they have paid the funeral bills,
right?
Say, all right, so I die and you paid my funeral bill, and it costs $10,000, and I died leaving only $9,000. You would have a right as a preferred creditor to come in, show that you paid my funeral bill, and ask for that $9,000.
Even if there is a surviving spouse under a will.
Well, that's a different argument.
That's a different argument. Okay.
I do think that a spouse is at the top of that list.
At the top of the list. Okay.
Yes.
Okay. I know there's some other questions that we want to get to before we go off the air, so I'm going to try to go through those real quick. Judge, what are the do's and don'ts of probate court?
Well, talk about what's going to happen if you die or become disabled with your family. Get a will if you have assets. Some people don't need a will if they don't have much. There's not much to leave. But here's what I found: the most troubling thing I find in probate court is that people will come in, the last parent has died, all of the dysfunction among the surviving children has risen to the surface, and they're fighting over stuff, because that is what we leave is stuff. And it might be record albums, it might be a lamp, it might be a set of dishes, and they're fighting over stuff. Try to work with your siblings and your family to resolve those issues before coming to court, because oftentimes, I'm just listening to facts, and if I can't determine who they belong to, I'm gonna have them sold, and the money's going to be split among the heirs. So I would encourage families to talk about what's going to happen. Talk to your parents about making an estate plan, at least making a will, maybe a living will, maybe a power of attorney, and plan a little bit ahead. You can avoid a lot of heartache if you do that.
Okay. Just a couple of other questions real quick. How do you avoid probate? And I think you may have touched upon
Careful
this
planning. Put your accounts in joint survivorship. Have beneficiaries for your life insurance or your retirement accounts. If you have lots of money, you can hire a lawyer who specializes in trusts, and they can write a trust to try to protect these assets from the probate estate. So there's lots of different things, but the main thing is you can plan ahead by having things in joint survivorship, by having beneficiaries on life insurance and other contractual policies where a beneficiary be appropriate.
Okay. Last question for you, and then I'm going to address two questions that I saw come across the screen, is recurring problems in probate court from this judge's view.
Recurring problems, failure to comply with the deadlines. 60 days after an estate's open, an inventory has to be filed. We have, often have problems getting people to file an inventory. Because when they file, they say, these are what we think we have. And then after 60 days, you're supposed to have an idea. This is exactly what we have.
Absolutely.
To file an inventory. After 6 months, actually in probate states, we don't require them to file a settlement after 6 months. That's the earliest they can do that. But after 2 years, some type of settlement has to be filed, either a periodic, if it can't be closed, or a final settlement. And getting people to comply with that statute and file those settlements. And, failure to file settlement is one of the reasons that we remove fiduciaries and appoint the public administrator.
Interesting.
So those would be the two biggest recurring problems I see in probate. And the biggest one I would say is this family dysfunction that occurs, and they're not really fighting over stuff. They're fighting over injustices that have occurred throughout a lifetime. And it's something that I can't fix.
Right. That is a very interesting way to put it. I was about to talk about one of my cases, and I know that that's exactly what was being fought over, where the injustices through life, not necessarily what the man had actually left. So I saw two posts here as we are about to wrap up here. Two posts. One talked about, and I think it was from John Yah. He talked about life insurance, and I'm just going to encourage you, John, to go back and listen to the broadcast, because we touched upon that earlier. His question was about, do you have to wait? I mean, how quick can you get the life insurance money and all of that? And we talked about how if there's a beneficiary name, that life insurance passes outside of probate and it has nothing to do with probate. So probate court has nothing to do with it unless somebody's challenging the validity of life insurance policy.
And we wouldn't handle that.
And no, you wouldn't handle that. But if at some point the life insurance company determines that the policy actually doesn't have a named beneficiary because the beneficiary form was not properly executed or something like that, then it goes to the estate. Then it will come through. But short of that, it's all a life. It's a contract matter, pretty much, right?
It's a contract, not a probate.
Okay. And then the other question was, she touched upon some life insurance proceeds. Melissa, we can't see your question now, Melissa, but I recall it. And Melissa was asking, she said something interesting at the end of her question when she talked about she has a healthy life insurance policy and she has two children. She has named them as beneficiaries. That's okay, because it's going to pass outside of probate. The life insurance company is going to call the children or their guardians if they're minors and say, hey, listen, we've got this money. We need to get this money to you if all the requirements are met. But the other part of her comment or question was, she said she came in late. She talked about what she has done with her holographic will. She has written the will and she has had it notarized.
I don't think that's a problem. I don't think that's a problem.
You don't think it's a problem?
No, as long as the body of and there are cases on, believe it or not, there's lots of law on holographic wills. The main body of the will, if it's written wholly in the testator's hand,
right, and that's what a holographic will is. It's a will just that's written by
the decedent. There could be a notary. There can be witnesses. They don't have to be. It can be dated, but it doesn't have to be. As long as those elements are present, Kentucky law tends to favor those being valid wills.
Okay, interesting. Well, that is our time. I hope you all have enjoyed this broadcast tonight. We were talking to Judge David Bowes about best practices. Me and DJ Ice, as we normally do, we're here on Thursday night. So I want to say thank you guys for joining us, and Judge Bowes, thank you. It was a pleasure to have you. And I know sometimes it's difficult to come back downtown. For those who don't live downtown, back downtown at 9 p.m. to do the broadcast. But we really appreciate you being here. I think we've passed on a great deal of information.
One of the best trials I ever presided over in district court was Carl Price and Scott Cox. It was one of the most professional trials I ever had, and I'll never forget that trial.
Well, thank you. It was probably a gun case, right?
It was a gun.
It was a gun case when I was head of the gun unit. Okay, well, great. Well, listen, everybody, absolutely. We talked about that anyway. Thank you all for joining us here on Conscious Fever, here on 97thebeatfm.com. And again, as I sign off, you've been listening to Conscious Fever. I am your host, Carl Price. Thank you for joining us. And you've been listening on 97 The Beat FM and 97thebeatfm.com. We will be back next week. We'll probably do something Christmassy if we don't get any of these new judges. We've been trying to get some of the new judges to come on and give us a 30-minute spiel about who they are and what the bench can expect. But until that happens, we'll be back next week regardless. Good night, everybody, and thanks so much for joining us.
You are listening to Conscious Fever, hosted by Carl Price on 97thebeatfm.com.
Stand up. Kentucky, whether you're a mother or father or uncle or aunt or a person great at using contraceptives, save this date, grab a sitter, make Uber your designated driver because you don't want to miss the Bad Dads of Comedy Tour, brought to you by Big Mike's Comedy Blast, starring the very funny Gene Harden.
I'm bringing the Bad Dads Comedy Tour to your city. When you come right outside of TSA, in middle right, you're going to see the dogs right there. Let them sniff your ass for a little bit. Just keep going.
Along with the very funny Eric Da
Never seen
Silva.
the look on a woman's face when she gets more than she expected.
Hosted by the always ignorant Dwayne Cobb. Tickets can be purchased from Eventbrite.com or Jam Busters Balloons and More, or She Likes Beauty and Barber Salons. And remember, Clapping is optional, but laughter is a must. Get your tickets now.